Our sign language interpreter at the bottom end of your screen is Maresha Witi. Thank you for joining us. The Supreme Court has allowed the Standard Group, Royal Media Services and Nation Media Group to continue broadcasting on analog pending a further ruling by the judges.
Justice Kalpana Rawal issued the interim orders before a 7-judge bench earlier today. KTN's Abby Agina was at the proceedings and now takes a look at what this means ahead of the global digital migration deadline slated for the 30th of June this year.
The interim order will be extended.
It was a verdict that temporarily brought relief to the 3 media houses in the country in their quest for justice in the digital migration case. The case pitting media owners against the Communications Authority of Kenya was before the Supreme Court for hearing. And top on the lawyers' agenda was to seek for an extension of the switch-off date for analog. The 3 media houses have been seeking additional frequencies and a broadcast distribution license, which have not been forthcoming.
All we've been saying is that we, the 3 media houses, support digital migration. Give us a license, give us frequencies, give us time to transmit in order to bring in our equipment.
What we have given you is sufficient for now. What you want is for the whole country. You cannot get for the whole country now. This is a phased approach. As time goes by, you will get.
Although the Supreme Court judges heeded to the request for extension of the ruling switch-off date, the judges will be issuing a ruling on notice, which will clearly state the position of the court over the ongoing digital migration case.
We have substantially complied, and your task is only to see that there's substantial compliance with the orders in respect to consultation and a bit of give and take, which we have done.
As of today, there has been no compliance. We don't have the frequencies, we don't have the self-provisioning license, which they had issued to us. It would be atrocious for one to suggest, can I just finish? It would be atrocious for one to suggest that the authority has complied because they had issued us with a self-provisioning license, which they have now repossessed, or given us frequencies they have now repossessed.
The lawyers representing the media entities, namely KTN, Citizen, NTV and QTV, sought the court's direction over the recent revocation of the self-provisioning license by the Communications Authority as well. The judges deemed the matters not being up for consideration.
This mention was not necessarily triggered by the application we are making reference to.
In order to order transmitters, you must be allocated a frequency first, because that frequency needs to be configured in that transmitter. I think it's important to appreciate that transmitters are not things you go and buy off the shelf. You order them and they are manufactured.
The digital migration case has been rocked with several hiccups, which have questioned the government's commitment in awarding the local stations the digital frequencies they have been pushing for. So far, media houses have been allocated 21 frequencies against their request to have 56 to sufficiently cover the entire country. Foreign Farm Pang, which is associated with StarTimes, has received 122 frequencies, while Signet was awarded 54. Media owners were also recently banned from importing set-top boxes that would be sold to members of the public for a one-off cost of 2,000 shillings under unclear grounds by the Communications Authority.
Compliance with the orders is for us to have a self-provisioning license, to have a license, to have frequencies, and to be given time to import the equipment so that we can migrate. That to me is what compliance means.
And now, as the 2 parties await the court's verdict, TV viewers can only but hope for a favorable outcome into a matter that has remained contentious, raising speculations over the future of local broadcasters. Abby Agina, KTN.